Good morning. Welcome to Member Focus Monday. I'm Cristina Schaefer, Social Media Manager for HAR, and I am joined this morning by HAR's Legal Counsel, Grant Harpold. Grant, welcome.
Hey, good morning, Christina.
I should say welcome back. This is not your first appearance on our program.
No, I love being here.
Thank you. So we have had a very large amount of new members join us in the past year, and just since the last time you've been on this program. So if you don't mind, just if you could tell us a little bit about who you are and what you do.
Yeah, I'm Grant Harpold, and I'm legal counsel to HAR, and I'm a partner at the law firm Buck Keenan, and just love doing things for HAR and helping out and providing advice. So ready to do it again this morning.
Thank you. We appreciate it. We have a lot of members tuning in, all telling you good morning as well. So again, thank you for joining us this morning. We have quite a bit to discuss, and we like to get these updates from you because, of course, you know, there are laws, but there are things that change and new forms and new documents. So we've had you over the years discuss a lot of different topics, and we want to do the same this morning. The last time you were on this program, that it was just you, without the time before you were on the panel, we did hear a little bit about the NAR lawsuit that's going on. So if you could just first tell us a little bit about what it is for any members that aren't aware about it, and if you could give us a current day update, what is going on with that right now?
Sure, it's a lawsuit filed against NAR and some big nationwide brokers from the seller side, meaning that the seller is accusing or alleging that they paid an inflated listing commission because of the MLS rule that requires compensation to the buyer's broker. And so they're trying to make it a class action lawsuit on this basis that somehow the seller was damaged by paying an inflated price on the list side to their listing broker, because the listing broker then has to pay a commission or something, some form of compensation to the buyer's broker when using the MLS. And so NAR had filed a motion to dismiss. It had been pending for probably a year or close to that. Just last week, the motion to dismiss was denied. So that case is still pending. And so the next step will probably be discovery and all the other stuff related to litigation. There could be another attempt to dismiss it down the road. There could be an attempt to settle it. One day it could go to trial, but it's probably a case that's in for the long haul versus a short-term resolution. So it's still out there, it's still pending, and otherwise, it's just one of those litigation matters that will be dealt with in some manner over the course of probably the next several years.
Okay. Do you have any suggestions for members, maybe if they have clients or customers that ask them about it?
Yeah, I would tell them that it's litigation is uncertain and hard to predict, and this is NAR feels confident about their position and having the MLS and the way it's structured and the way the compensation's structured, and so just see how the court system and how they view it and how ultimately they decide whether that in fact is the right position or not. And so it will just take time to see where that ends up. And litigation is not something that people want, but it's not something that's an oddity in this country that we live in. I mean, that's just sometimes that just happens in the course of business.
Okay, very good. Thank you for that update. So the last time that you were on this program, you were actually on a panel. You were on our racism and real estate panel. And diversity and inclusion continues to be a hot topic in our industry. We've discussed it on this program several times. What advice do you have for realtors in regard to fair housing?
Well, I think that the key thing is the word fair. I mean, it would be as if how you treat your family or the people you love, your neighbor. I mean, kind of the word kind of love thy neighbor kind of applies to housing. I mean, be fair, don't discriminate, be receptive to people with different backgrounds and wanting to live wherever they choose to live, and don't steer them into one direction or not show them housing based on what you perceive or what may be in your system. They may not agree with your view of the world, and your view of the world should quite frankly, be, like I said, fair and loving and open, and an ear to what your client wants to hear. And so that's one thing. Just the concept of being fair and not dividing people up or not choosing a community because of how somebody looks or acts or culturally or religious, any sort of ethnic background that may cause somebody to look differently at them. That's something you should not engage in. Whether your client asks you those types of questions, you should not even answer them and tell them that's not in your DNA, and besides, that's against the law to delve into those types of issues as to the type of neighborhood or the type of people you want to live with. And likewise, when you inquire about a property, if somebody were to ask you who your clients are or some sort of descriptive nature of your clients, you should refuse to answer that question. On this, if they're seeking some ethnic or religious type litmus test of your clients, and tell them that's just not fair, that's not loving, and besides, it violates the law. There's one other thing that I just, in kind of reviewing this, that I think brokers or people who have an office need to remember, that you should have, I think we have a picture of it, you should have a equal housing opportunity poster at your place of business that's on visible display, that when people come, they can see that your business that follows fair housing and equal housing opportunity under the law. And it's a poster. It's I think it's 8 by, there it is, that you place in a prominent or visible position in your place of business. And so if you don't have one at your office, then I suggest that you get one, because that is the law, and or my interpretation of the law, and it's a good thing to have anyway. And you can find these online. You can specifically complianceposter.com can get you these posters to post at your place of business. And it's, like I said, it's the law, and it's something, in looking at all this and kind of bringing this issue to the forefront, that just I'm reminded by this particular thing that it's a good piece of information to have posted at your place of business, and besides, it's a requirement.
Okay, very good. Thank you for that. And can you repeat that website just in case anyone missed it?
Yeah, it's and there's multiple. I think if you just Google, you'll find it. But this particular one that I saw was complianceposter.com.
All right.
And they have the exact poster you just put on the screen, and they can ship it to you, and it's a pretty easy process. And if you need any help and further help on this issue, you can go to HUD. You can Google this issue. You can. It's out there, and it's pretty easy to find. Even though I think the complianceposter.com even describes the instructions for using it.
Wonderful. So, kind of keeping in line with that fair housing topic, are there any special issues or policies in regard to COVID-19, or in general as it pertains to fair housing?
No, I think COVID-19 doesn't all of a sudden say, well, because of the stress and so forth of the virus, we don't apply fair housing anymore. Fair housing still exists, even though COVID-19 exists. And so the rules still apply. There is no exemption, no special waiver because of COVID-19. And if somebody has an issue with COVID-19, you can't treat them differently. You can certainly do things to protect your health, as far as who can be in a property, and maybe you can do a virtual tour or have a representative come for that person to tour the property, but you can't discriminate or deny people because of their current situation or their current health situation. And so that's something to keep in mind, that all of these rules still apply, and you're allowed to ask questions about COVID-19, but you can't take action that prevents somebody from accessing or using or buying or leasing a piece of property. You certainly protect yourself and do things to minimize the risk, like I said, by having a virtual tour for that person, or having that person send their own representative if in fact they're actively carrying the virus. But otherwise, it's business as usual.
Okay. All right, thank you. So I have a few more questions for Grant, but if you have any questions for Grant, be sure to type those into the comments, and we'll get to those in just a little bit. You recently spoke for the HAR Virtual Engage Conference, and you made some really interesting points about buyer's agents potentially putting themselves at risk when it comes to seller's disclosures with specific regard to flooding, can you tell us a little bit about that and what buyer's agents can do to protect themselves?
Well, kind of getting back to the NAR lawsuit, I mean, buyer's agents are somewhat under attack. And so, I view a buyer's agent as bringing real value to a transaction, even if the property's already been found by the buyer on HAR.com or Zillow or some other portal. I mean, that doesn't diminish or minimize the value of the buyer's agent. And most specifically, it comes into play on the seller disclosure notice. So I came up with 4 things to remember on seller disclosure for a buyer's agent. 4 C's. Make sure it's complete. So when you get the seller disclosure notice as the buyer's agent for your client, make sure that the seller disclosure notice is complete. That's critical. Sometimes they're not, believe it or not. Sometimes a listing agent misses something. Make sure that what's in the seller disclosure notice is consistent, meaning that if it says flooding somewhere, a disclosure there, but then somewhere else it doesn't say the same disclosure, in fact, it maybe says something different or incomplete, then we have an inconsistency. And so that leads you to the next C, consult. If you see something that's inconsistent or perhaps is not descriptive enough, you should consult with the listing agent, get more information, inquire as to why, you said flooding onto the property or that it came up to the porch or that it came into the kitchen. Find out other questions you should be asking. And so when you find that information, and I think if it's material information, it's being told to you verbally by the listing agent, you buyer's agent getting it verbally from the listing agent, you should confirm it. So that's the last C. That's the last of the 4 C's. Confirm what the agent just told you. Confirm it in an email. Have that agent send it to you in an email. If that agent won't send it to you in an email, then you send an email or some sort of confirmation back to the listing agent, just confirming what you just told me. The water came up into the kitchen, or the water only got into the garage, or the water only got to the front steps of the sidewalk, whatever. And this would apply to any sort of defect, not just flooding at the property. So I think it's the seller disclosure notice is critical piece of information, kind of the start of the process of the information gathering, and the buyer's agent is a critical component in that, because a lot of people, let's face it, the seller disclosure notice is pretty voluminous. And so first-time home buyer, even a seasoned home buyer, can be kind of overwhelmed in reading this and kind of really picking out what's the stuff I really should pay attention to,
what's
or what I should pay. Yeah, exactly. And so you're there to help. And so I think that's a critical function of the buyer's agent, and it's big time important in the process. Like I said, even if the buyer's already found the property, this step in the process of purchasing the property, the seller disclosure notice is huge, and the buyer's agent has a big role in that. And if they don't take a big role in that, then they're susceptible to being negligent or not doing their job. So get involved and act on that. And so anyway, I mean, that's huge. And in the context of that, you need to provide your client advice. I mean, you are the professional, you are the expert. And so relative to the knowledge you get from the seller disclosure notice or whatever, provide advice to your client. Now that doesn't mean they have to accept it. Don't get your feelings hurt if they don't, but you still need to provide that advice. Tell them something. Don't leave it hanging. Provide advice means I'm active. That's a verb. I'm giving them something to take and use, and so fulfill that role and provide advice.
Very good. So make sure it's complete, consistent.
Yes.
Then we want to consult and confirm, and then provide advice. Very good.
Yes.
Excellent.
And it's all under this umbrella of being an advisor, and you are in this transaction. You're a critical component, or you should be.
Okay. Very good. Denise had a question for you, Grant. She asked, what can you do when the seller's disclosure is incomplete as the listing agent or the buyer's agent?
Well, as a listing agent, you need to consult your client, the seller, and have them go back and make it complete. Point it out to them. So that is part of your duty as a listing agent, to make sure it's complete. if you're the buyer's agent and you see it incomplete, you need to make sure, go back to the listing agent and make sure the listing agent gets their client to get it complete. It's a strong possibility that if the seller disclosure notice is incomplete, especially in regards to material information, you may not satisfy the earnest money contract where it says the seller disclosure notice has to be provided in so many days, and if it's not truly provided in the sense that it's incomplete, then the buyer could walk the contract, could terminate the contract down the road on the basis that the seller disclosure notice was never really provided because it was so inadequate.
Okay.
So that should be a concern for both parties.
Okay.
For both agents, listing and buyer.
And a big thank you to Teresa. She provided a direct link to that poster for everybody in the comments. So if you're looking for that, go look for Teresa's comment there. Dia had a kind of a question here for you as well. She said she's noticed more listing agents not providing the HAR 400 notice to purchaser form in the MLS. Some have even asked a buyer's agent to provide. Where on the seller's disclosure does the seller mention drainage district, if at all?
Well, it's in the seller disclosure notice. I'm not sure what more she wants on that question or that issue.
Okay.
If it's incomplete, again, or if it's not, whether it be that question being asked of the seller or any question, if it's not answered or if it's skipped over, go back and get it answered. I mean, that's if you don't, whether you're on the listing side or the buyer side, that could be a error or omission that could subject you to responsibility.
Okay, great question here from Alicia. If the property is on a second floor and the property on the first floor flooded, does the seller have to disclose that the property below flooded?
Well, not if it's not the seller's property. I mean, if I disclose what I own and what I'm selling, so that's what the seller disclosure notice covers is the listed property that you own and that you've put on the market for sale.
Okay. Denise asked a question, and I don't know if you have the answer to this, Grant, but maybe you could provide them some advice. She said, should we use the floodplain overlay basically in Matrix, and what if it doesn't match up?
Well, I think you can use it as a fact gathering sort of general information, but I would not necessarily rely upon that, or certainly put disclaimers on that, because ultimately that information will come to you from the survey, and that will be the most, and that will be from a sourced third party, which provides you protection, provides your clients protection, and is the most accurate information. Which reminds me, Cristina, I think still some agents, and this goes back to the buy side of the transaction, are missing the building ordinance within the city of Houston. So coming back to this floodplain issue, where that's really becomes critical, is the base flood elevation, BFE. And so if your property that your buyer is looking at, and maybe one day they want to tear down, or maybe they're just buying a lot, whatever it may be, they need to be conscious of the fact that if you're in the city of Houston, and it's in the 100-year or the 500-year and floodplain, that the base flood elevation where that crosses the property is critical, because your finished floor is going to be 2 feet above that. So I've tried to break that down as being as simple as possible, but if you're in the floodplain, it's really 100. It's not, if you're in the 100, you're in the 500. So really just look at the 500. If you're in the 500, which means you're in the 100, and you're thinking of building on that lot, if it's vacant or tearing down the road, if it has a structure on it, you need to be aware of the fact, and maybe it doesn't matter to you, but I think the buyer should alert the buyer's agent should alert the buyer to this fact that this ordinance exists, and the finished floor is going to have to be essentially 2 feet above the base flood elevation, and the base flood elevation again will come from your survey, relative to that property.
Okay. A few more
so that's
questions.
a city ordinance, and it's hugely critical on new construction.
Okay, very good. A few more questions coming in here. Some still in regard to flooding and seller's disclosure, and some moving into other topics. So I want to try to get some of the seller's disclosure ones first, and then I will go back to some of the others. John said, as a realtor, we are not allowed to assist the seller when they fill out the seller's disclosure. Is this still true?
True.
Yes.
It's a seller, I mean, just to keep it simple, it's the seller's disclosure notice. So this should be information coming from the seller and prepared by the seller. Your role as a listing agent is to make sure it's completed, and you know, if there's something that you note on the disclosure notice that is just total conflict with your knowledge of a certain issue, then you could raise that with the seller, but it's not your duty to fact check the seller disclosure notice. It is your duty to make sure that it is completed.
Okay. A quick question here. Rubrina said seller's disclosure on clear lots, no structure on the lot. So
you know, I think there's a use in the seller disclosure, a limited use of the form in that sense, especially in regards to flooding, that can be helpful. So that information from the seller disclosure notice, limited, because obviously you can't answer all these questions about the house or the structure because it doesn't exist. But there are questions that would apply to the property that you could still use the seller disclosure notice to provide that information to the buyer, and the obvious issue on that is flooding and the floodplain questions.
Yes. Marty brought up a good point here that I've seen brought up before. If the seller lives out of state, they've had tenants occupied in that property for several years. The sellers haven't seen the property during that time that the tenants have been occupying. Who fills out the seller's disclosure?
The seller. I mean, still the seller. If the seller doesn't have that information, then you can answer in that regard on the seller disclosure notice, because it requires your knowledge. And if you don't have knowledge, then, or if you don't know, or if it's unknown, then, you know, it allows for you to answer it that way in the seller, in the form itself.
Okay, very good.
And additionally, I would add to that, you know, I would make whoever aware that that's the situation. This seller has it. You know, I would add that in some sort of form or some sort of email, some sort of documented presence to the buyer's agent or to the buyer that, hey, this has been a tenant property. The seller has not, you know, and so, you know, you can always add to the information you're providing or qualify it in that sense. And I think that would be helpful to the buyer to know that the seller hasn't lived there. And so, and the information is coming from the seller in that situation.
From the seller's, the seller's knowledge. Okay, very good. So I'm going to ask one more question about representation, then I still have another question for you, and I know we're running close on time. Erica asked a question about representation. What recourse do you have if you have a signed representation agreement, and without discussion, the buyer puts in an offer with another agent?
Well, if you have I presume she's saying you have a signed buyer's representation agreement.
Yes.
You know, I think you need to contact your own client and remind them of that, and B, contact the broker of the agent that's involved in now making the offer on the property, and let them know that you're, you know, this client is your client.
Okay, very good. You know, I had another question that just I was just reminded of that was submitted to me offline, and it was about, kind of going back to fair housing for just a moment. It was about what do you do if you find yourself in a situation where they are refusing to maybe show a home or even return a phone call to another realtor because of the clients that they may be representing? What is your advice there?
Well, if that exists, there's multiple things you can do. You can file an ethics complaint with Texas Realtors, because that is potentially, if it involves a licensee or a realtor, more specifically, that I think it's Article 10 or Article 11 of the NAR Code of Ethics, and so that could be an ethical violation, and then that you can find that can be filed with TR, Texas Realtors, and secondly, you can file a complaint with HUD. and then they have their administrative process too. So you could actually do two things. And now that I'm thinking about it, you could do three things. You could file a complaint with TREC.
Okay.
And so Texas Real Estate Commission. So there's three ways to try to deal with that. If you can't, through love and fairness, get this person to see how the world should be viewed.
Very good. So, that was actually submitted to me offline by a newer agent who's just a little nervous about it, so needed some guidance there. Wanted to discuss a topic that I've seen swirling around a little bit again. We had the coming soon status put in place May 1st, but there still seems to be some confusion around how to use the coming soon status and how to remain in compliance with that. So can you explain to us how to use that and how to stay compliant with coming soon?
Well, I found Sean at HAR gave me this link, and I went to the link, and the link is beautiful. It answers all your questions, everything you want to know about coming soon, just so clear and so well done. So if you go to har.com/coming soon, it's real simple. And I had it somewhere, but anyway, har.com/coming soon. It lays it out perfectly, everything you want to know, and so because it's a good subject, and there are maybe some lingering issues, but it's a pretty simple process. And getting back to the role of the buyer's agent, kind of where we started. If I'm a buyer's agent, I would be wanting to be receiving notices of coming soon properties, because you, as the buyer's agent, can see a coming soon property on the MLS that's not yet on the portal. Mm-hmm. So if it's in coming soon status, and you're publicly marketing it, it's in the it should be in the MLS, where it possibly could sit for 14 days and not be on har.com or on any other portal. So you, as a buyer's agent, should be, looking at coming soon status properties, because you could get a kind of a head start on a property before it hits the broader market. Mm-hmm. And you can set up, just like you get notices of other properties in a certain area, you can get a coming soon. You can add that to your notification process to help you, again, do things on behalf of your buyer. But go to that link. That link lays out everything you'd want to know about coming soon. And I looked at it, and it was just blown away how easy to grasp the issues or answer all your questions that you might have on your mind.
Excellent. Thank you. And I see a few people shared that in the comments for us. Very good. John had a question here, and I'll probably make this one of the last questions before we wrap up, because I know we are getting short on time. Basically, this might kind of go back to fair housing here. I'm renting a condo. The HOA says they have to approve applicants. Can they do this? Can they request a credit report, especially without posting qualifications?
Well, I think the credit process is part of it. That's not an issue within the fair housing. So, the key in all of that is that if it's uniformly being applied, you can't somehow trigger a credit process to where you're disqualifying people for other reasons. So it needs to be uniformly used, but credit issue or credit background or credit type qualifications are common.
Okay. Are new construction builders required to give you a seller's disclosure notice?
Well, I think there is, now you would hit me here at the very end with a tough question, but there is there is an exemption, and I think, without looking at the exemptions in front of me, but that and I'm sure somebody else probably knows this, but I think that might be an exemption, because there are not every property is subject to seller disclosure. Like a property in a state. In a new construction, I'd have to look specifically, but that's something that's easily answered.
Very good. Well, Grant, as always, you provided us a ton of great information. Our members are already thanking you for this informative topic. Do you have anything else that you want to share with our members before we close out today?
Well, I think kind of the theme of a lot of this was, the buyer's agent is relevant to the transaction. And if you're not, you need to be, because there are a lot of things you can do and still do to help your client get to the closing, even if they found the property themselves. And I'm sure the listing agent would greatly appreciate a very active, involved buyer's agent. And lastly, be fair. Be fair to everyone. Be fair to your client specifically. Be fair to other parties, no matter what side of the transaction you're on. Don't think because people look a certain way or come from a certain religious background that they should only be over here or over there, or we talk in these sort of languages that really we shouldn't talk in about the script of what people should be and where they should be living. Houston is a very open and diverse society, and it's very enjoyable that way. So let's promote that. Let's not inhibit that.
Very good. Thank you, Grant. Steve actually said in the comments, bring him back again. These legal issues can't be reinforced enough. And we definitely will. We try to have Grant on at least once a quarter if we can. So thank you again, Grant. Next Monday, we are flipping it around a little bit. Our PR manager, David Mendel, will be asking me the questions, and we're going to be discussing marketing in 2020, what's changed and what hasn't. So be sure to tune in next Monday at 9 a.m. Have a great week, everyone. Bye-bye.